One, two, three. Good morning, everyone. The first case up today is Indiana Protection, let me get the entire caption here. Indiana Protection and Advocacy Services Commission versus Indiana Family and Social Services Administration et al. We'll be hearing first from the appellant, Ms. Mapes, is that correct? Mappes. Whenever you're ready.
Thank you. May it please the court. I am Harmony Mathis, representing the appellants, the Indiana Family and Social Services Administration, or FSSA. We are before the court this morning following a preliminary injunction ruling with respect to one of Indiana's Medicaid home and community-based waivers. The waiver program at issue here, the health and wellness waiver, does not allow the parents of minor children to be paid to provide attendant care to their children. It instead allows them to be providers of a service called structured family caregiving, designed specifically for situations where there's an enrollee that has a live-in caregiver like a parent. The district court's preliminary injunction ruling, however, ordered the state to violate the terms of its waiver and federal regulations when it ordered FSSA to pay the mothers of the two individual plaintiffs attendant care for their minor children, 84 hours a week for GS and 112 hours a week for ER.
Ms. Mappes, can I ask you a quick question? I was trying to decipher this myself and couldn't come up with a definitive answer. Are the services that are previously eligible under as categorized as the ATTC kind of subsumed within the FSSA kind of umbrella?
So
how are they different, or are they the same?
Certainly. So ATTC is attendant care, and then SFC is the structured family caregiving. Both of them fit the larger umbrella of personal care services. So some of the regulations and the guidance talks about personal care services. Both of them fit into that framework and allow the provider to provide hands-on assistance, hygiene, mobility, food prep, those sorts of things. There are differences, and that structured family caregiving is specifically designed for situations like the ones here where they're parent caregivers. Structured family caregiving allows for respite care. It's built in. That does not exist with just the straight up attendant care services provided by a non-legally responsible individual. There's also training that's involved, understanding who these caregivers are. There's training that's not part of attendant care. There are home visits with nurses or other aides. And then a big difference is how you record your time. Structured family caregiving is per diem, whereas attendant care is hourly, and that is designed to fit the situation where you're at home. We understand that you are the caregiver, you may have other children to tend to, other tasks, and you're not required to clock in and clock out as you're switching back and forth between what you're doing. So those are the similarities and the differences.
Before digging a little further into the merits, Ms. Mappes, you all had raised a perhaps academic jurisdictional issue. Could you direct me to the language in Rule 65 that requires a preliminary injunction to be in a separate document?
Off the top of my head, I cannot do that. I agree with Your Honor that it's an academic.
Off the top of your head, or with all the study in the world you want, you could not. Our case law has made it up, but...
Off the top of my head, I cannot. I understand that's a requirement, and I understand that we believe that requirement has been satisfied here, given the detail in the order.
Thank you. Could I ask you on the merits, if I understand the state's position correctly, if for these two boys, if any human beings other than their mothers or legally responsible individuals were willing and able to provide the attendant care that the plaintiffs are seeking here, the state would be willing to pay those individuals at the ATTC rates, correct?
If plaintiffs were seeking that, yes, we would provide the attendant care rates for a non-LRI to provide the care.
So an uncle, a grandmother, a neighbor.
Correct. That is allowed under the waiver, and what plaintiffs seek is not, and it's prohibited by federal regulation.
Well, we'll talk about that in a moment, but why does that make sense?
It makes sense because that's what the law is, right? The waiver.
Well, the law is a lot of the law is what FSSA chooses it to be here. in the way the waiver is written and is worked out with the federal government, as we've talked about the state tying its own hands with red tape before, right? So let's talk about why it makes sense to say we'll pay mothers $100-something a day, but we'll pay other relatives and other people $30-something an hour.
Certainly, and that comes down in large part to extraordinary care, right? The existing regulation, the existing waiver, the existing CMS guidelines specifically all say that LRIs are not allowed to provide attendant care unless you go through these many steps. It's not just a simple check the box that plaintiffs suggest. It is an option under the waiver only if you go through a litany of things, including providing an extraordinary care definition, which requires the state to distinguish between...
Have you done so?
Has FSSA done so? No, because FSSA has opted not to create a waiver that provides this service.
So, but federal law allows payment of the mothers or other legally responsible individuals for extraordinary care, correct?
Only under limited circumstances, only where there is an approved waiver, where there's a definition of extraordinary care, which is contemplated to include limits and caps. Those have to be found fiscally sustainable and cost neutral. You would have to go through a notice and comment process. All of these steps to implement and to make what plaintiffs seek legal constitutes a
But
fundamental
none of which
alteration.
the state has actually tried to do in this case, correct? You say you don't want to provide this payment to mothers.
I don't think it's a matter of want, Your Honor. The state considered, can we create an extraordinary care definition that would allow for what plaintiffs want? And the answer was no. We've considered this and don't believe we can do this.
And is that consideration documented somewhere? So, for example, in discovery, if the plaintiffs were to issue a document request with regard to the analysis by the agency with regard to this issue, is that in writing somewhere, or how would they go about getting it?
So what's in the record right now, I can point you to two places. There's a declaration from Kathy Robinson within the agency. It's at docket 38-1. And she explained that if we were to embrace an extraordinary care definition, as CMS suggests, we'd have to put limits on that. And their understanding was we would have such a narrow definition of what's extraordinary care that it would leave individuals perhaps without services, which is part of why they opted to go with structured family caregiving. There's also in the waiver itself, right, that you submit to CMS, FSSA acknowledges we considered doing this and we determined such a change was not fiscally sustainable. And so our option for LRI provided care is the structured family caregiving. And we have not gone through these numerous steps that you would have to take that constitute a fundamental alteration to the program as it currently exists.
And Ms. Mappes, as a procedural matter, the fundamental alteration kind of defense, would that be considered an affirmative defense where the state bears the burden of proof?
On the fundamental alteration piece, yes, Your Honor. There is the sort of the flip side of the same coin, which is the third prong of the ADA, which asks, is this a reasonable accommodation? We think it's not what plaintiffs seek is not a reasonable accommodation. We also think giving them what they're seeking would constitute a fundamental alteration.
With regard to the argument about fiscally responsible, getting back to what Judge Hamilton was saying, if the state has put aside sufficient money to pay non-LRIs for performing these services, how would limiting the services providers to non-LRIs help the state fiscally?
So part of what led to the situation we're in was that, contrary to the waiver, individuals were in fact approved to provide this service, and it became not fiscally sustainable, right? So there isn't money allocated for this, right? Expenditures under the A&D
So I guess
waiver.
I understand that. That both sides have outlined those arguments well in the briefs. I guess my question is, has presumably the only way that the state would save money is if they thought that by preventing LRIs from providing attendant care services, that they wouldn't get an equal number of claims for non-LRI people to provide the same services. Because if those numbers were equal, then the state would not be saving any money. And my question to you is, has that analysis been done? And if so, where would we be able to find that?
If I understand the question, I don't believe that precise analysis has been done. I think that's not what plaintiffs are looking for here, right? They're looking specifically for their mothers to be able to
Oh, I know. I'm
provide.
just looking at the fundamental alteration argument, right? You say that it was for fiscal reasons that the state kind of limited the program for LRIs to the structured family care. And I think Judge Hamilton made the point that, well, if it's non-LRIs are providing the attendant care, then the state would have money to pay. And so presumably, in order to save money, the state did some calculus to conclude that for, in the latter case of non-LRIs providing attendant services, that would cost less money than if LRIs were providing attendant services, right?
I understand your point. I think part of the issue, right, wrapped into this, when FSSA identified, right, the fiscal concerns, there was an overall re-looking at the program, and there were other issues as well. There were automatic approvals that were happening, right, and we sort of circled back to person-centered planning. Let's make sure people are getting the services that are fit best, that are designed for them, and so it's a more of a holistic approach. I don't think that the precise numbers you're looking for exist, or at least certainly not in the record.
In the current record, where would we be able to find the most detailed articulation by a state witness as to why they went this route for fiscal purposes?
The fiscal piece, a combination of Paul Bowling's declaration and Kathy Robinson's declaration that I mentioned, and perhaps Cora Steinmetz as well. Their declarations spell out the fiscal concerns and why FSSA made the choices that it did.
Sir, who was the third person?
Cora Steinmetz. She's
Steinmetz,
the
okay.
OMP
Thank you.
director. I will say, Your Honor, I don't think the court has to reach the fiscal question in order to determine that there was a fundamental alteration, right? Plaintiffs are seeking services that do not exist for anybody else. Vaughn has instructed you do not have to go outside the existing services. I think that is not a reasonable accommodation to give to just these two. I think plaintiff's response is, let's amend the whole waiver, and here our position is, even if you don't reach the fiscal question, the steps that are required constitute a fundamental alteration, even if you don't consider the monetary component. You would have to amend the existing waiver. So you have to provide a definition of extraordinary care. You have to determine what other limitations go on the service, right? CMS has suggested, right, you need other limitations to differentiate between ordinary care and extraordinary care, right? There, from the CMS technical guidance on page 120, they specifically suggest a safeguard that would limit the amount of services that a legally responsible individual may furnish. Their suggestion in the guidance is to limit it to no more than 40 hours a week and, quote, thereby take into account the amount of care that a legally responsible individual would ordinarily provide, end quote, right? So you have to amend the waiver, provide the extraordinary care definition, figure out, okay, what caps, what limits do we need to put on this to fit within CMS framework. You have to ensure that the waiver is fiscally sustainable.
But I guess I'm having trouble with this, Ms. Mappes, because as I understand it, it's the state that is changing the status quo here. That is, in these two families, the mothers were providing, I'll call it extraordinary care by at least a layman's definition. And then the state decided to make changes in the program and in the funding. And now you're saying it's too much work. It would be a fundamental alteration basically to restore the way things were before this policy change. Is that right?
FSSA's position is restoring things to the way they were before is not an option. FSSA...
That is, however, I have described the history correctly.
You described the history, except what was happening before was not fiscally sustainable, and it was in violation of the waiver, right? We have to be able to fix mistakes and go back and realize that. I also think assuming that what mothers are providing is necessarily going to be extraordinary care completely nullifies the well-established dance that goes back and forth between CMS and the federal government. even if you assume, okay, what they're doing is extraordinary, it's certainly challenging. That doesn't mean all of those hours would then meet the definition, because you have to distinguish in order to allow this and have what they're asking for be legal in the first place. You have to establish definitions for that. And that is clearly a process for CMS. You have to go in the state.
What you seem to be saying is that any waiver, as I understand it, would be in essence beyond the reach of the integration mandate under the ADA and Rehabilitation Act, because compliance would require all of this hard work that would amount to a fundamental alteration in the program. What am I missing?
I disagree with that.
Please.
Right, you certainly could decide that any amendment.
We're not going to decide that all waivers are immune from
Understood.
the integration mandate.
So I think this case is different for at least two reasons. There's a federal regulation that, absent going through this process, bars the LRI provision of attendant care services. That is not the case for other options under the waiver. It is not the case that just the state by itself can check that box. There's a federal regulation that prohibits it. That's not going to be the case.
Is that 441.360 D?
Yes, CFR 440.
Okay. Give us your second reason.
440.167.
Sorry?
440.167, 42 CFR 440.167 prohibits personal care services that are provided by a member of the individual's family. That's what I was referring to. The other piece of this, I will say, is I think in most instances, many instances, what the plaintiffs seek is not going to be so specific as we need a waiver amendment. For example, in Stymel, the court described the court on remand would not have had to structure a remedy that necessarily required amending the waiver. And here plaintiffs have conceded the only legal path forward to give them what they are seeking would require an amendment to the waiver. I am well into my rebuttal time.
We'll give you some more time on rebuttal. If you want to spend a couple minutes to address the Medicare Act, Medicaid, I'm sorry.
Yeah, go ahead.
The Medicaid Act claim?
Certainly. And I can be brief about that, Your Honor. I mean, our position is that FSSA has complied with its obligations under Medicaid law, right? The OB decision sets forth states must do something, right? That case, there was nothing. Here, FSSA has taken reasonable steps to identify nurses for these individuals. We have a list of providers. We have care managers who work with the individuals to do this. In this particular instance, right, we had several thousand individuals transitioning over to this new framework, right, to correct the out of alignment with the service care definitions. And the vast majority of them have gone through that transition process, right? 68% of them have transitioned to structured family caregiving. The rest have non-LRI attendant care, or they have found nurses, right? And it's our view that in this situation, we have complied with the obligations under Medicaid law to make services available, and to the extent they aren't, they are for reasons that are outside of FSSA's control, either situations specific to these individual plaintiffs, right? We've highlighted since the court's order, there have, demanding schedules. For example, ER is requesting that nurses provide 12-hour shifts on the weekend, right? That makes it difficult to find a service provider. And to the extent there's a national nursing shortage that the district court agreed with, plaintiffs agree with, we've cited evidence for that. As much as we may want to, an order from this court is not going to solve that problem.
You seem to be arguing that plaintiffs are not at risk, at serious risk of institutionalization, a subject we haven't talked about yet this morning. Put aside for the moment questions about appellate review of district court's findings on that point, particularly at a preliminary injunction stage. But you seem to be arguing that the plaintiffs are not at serious risk of institutionalization because they have not been using all available hours for skilled nursing care. Is that right?
That's a piece of it. I don't think it's accurate to boil it down to just that. We, in a declaration from FSSA's medical director, who looked at the information they would typically submit.
This is Dr. Fennell?
Yes, it's Dr. Yes,
Did
Dr.
she ever
Fennell.
examine these boys?
No, but she's not giving a medical opinion, Your Honor. She's looking at the same information that the agency would look at when you're evaluating how many hours of service do they need, what type of care fits. It's certainly not a medical opinion. Doctors do not typically examine enrollees at this point in the process, right? They
What
look
kind
at
of an opinion is it?
it's an opinion about what level of services are appropriate based on the information that has been submitted.
She used her medical training, I assume?
Yes, she did.
Okay, sounds
It's
like
not
a medical opinion
diagnosis.
to me.
It certainly. I just want to be clear. She's not diagnosing them, right? It's not that type of medical opinion. Appreciate the clarification. She outlines in her declaration different ways that plaintiffs might be able to have their needs met. We think all of those are viable, and I think FSSA is optimistic.
Have you
that,
thought about bringing the schools into the case? You want to say, well, the plaintiffs aren't getting all the help they need that they're entitled to from the schools, right? Why not bring them into the case too?
I suppose we could consider that. They're not part of the case right now, and it's our position that Medicaid should not be obligated to fill that gap, right? That's not a Medicaid issue of whether schools are
If you're in the
providing
position of
care.
these families, you're looking for all the help you can get from all those different directions, right? And there, I thought I did read in your briefs, you were arguing that the plaintiff's failure to use all available hours for skilled nursing care tended to show they were not at such serious risk of institutionalization. What did I miss?
If you look at their historic usage, right, if there are points in time prior to their mothers ever becoming LRI providers for attendant care where these individuals were not institutionalized, they were doing so without all these hours of nursing. We suggest the past is
Do you
likely
think the
a predictor
national
of the
shortage
future.
of nurses might have had anything to do with that inability to employ people for all those hours?
I think it's certainly possible, but I don't think that's outcome determinative here.
It just
where-
tends to undermine the argument that the failure to use all those hours tells us anything very material.
I think it demonstrates that these individuals have not been institutionalized before. Given that everybody else who has gone through this process has transitioned to something else, FSSA is certainly optimistic that these two individuals would be able to do that as well. And it's not surprising that that has not gone through already. These individuals are receiving tax-free near six-figure salaries to care for their own children, right? They're not incentivized to go through that process. We are optimistic given what's in the record.
Counsel, when you say the six-figure salary, the mothers are employed by an agency that takes a cut of that, correct? Somewhere between 30 and 40%. So the numbers in the state's brief are a little inflated.
There is
that right?
evidence in the record that for certainly one of them, I think is over 100,000. The other one is slightly under. It's tax-free. There's a provision that says when you're providing this care, it's not.
But they don't get that entire amount. That's the amount paid to the agency, and the agency takes a percentage cut. Am I understanding that correctly?
You are understanding that correctly.
Okay.
I still think the totals get to what we recited. But yes, that is correct.
Anything else?
Let me just check something. I did want to ask you about a hot subject lately in this court and the Supreme Court has been the use of Section 1983 to enforce various provisions in the Medicaid Act. And the Supreme Court heard oral argument on a case along those lines last week. If Section 1983 is not available for these provisions, what effect would that have on the district court's injunction, given the reliance as well on the ADA and Rehab Act?
So I think that would, our position that would resolve the entire case on one hand, right? The Medicaid claims would therefore be out. And our view is that as we explained in the papers, what plaintiffs truly seek here is a rate increase, which would also be barred.
Well, they're not seeking that, they're not going to get it under Armstrong. But I don't see how a decision on the availability of 1983 affects claims under the Rehab Act or the ADA.
So, I guess 2 points. One, it's our position that what they are seeking is in fact a rate increase that is not redressable by the ADA. So I think there is an avenue to get to that, right? If the 1983 claims under Medicaid are barred, you cannot end run around that by bringing an ADA claim. Our view is the ADA does not speak to the rates, right? You could imagine just two similarly situated individuals whose medical needs are essentially the same, but then we're looking at, well, what is your family situation? How much money does your parent make? What are the other needs in your family, right? The ADA does not dictate and speak to that situation. Setting that aside and assuming you have an ADA claim, our position, as previously explained, is that what plaintiffs seek is not a reasonable accommodation. Under Vaughn, it requires you to go outside of the
We
waiver.
just stay under the ADA.
Yes, and
So
fundamental
The
alteration.
case does not necessarily depend upon Section 1983.
If you view it that way, no, it does not.
Thank you.
Anything else, Nancy?
No, thanks.
Thank you, Ms.
Thank
Bates.
you.
We'll give you 2 minutes for rebuttal.
Appreciate it.
Mr. Rose?
Thank you, Your Honor, and may it please the court. The state cites 42 CFR 440.167 as authority for its proposition that federal regulations do not allow for the provision of LRI-provided attendant care. The first 8 words of that regulation are unless defined differently for purposes of a waiver. Quite clearly, I think everyone acknowledges that this is something the state could do and can be compelled to do under the ADA. In fact, its current H&W waiver document contains a definition of extraordinary care. It just does so under the rubric of structured family caregiving rather than attendant care. The state's, I believe, vastly overstating what would be necessary to bring its waiver document into compliance with the ADA. So much of its argument depends on its insistence that when the Medicaid Act allows it to do something, the ADA and the integration mandate cannot compel it to do something else, and that simply is not the law. This court explicitly rejected that argument in Steimel. If that argument is correct, Radishevsky was wrongly decided. Obviously, the Medicaid Act allows for the removal of home nursing, at least for adults. The CMS's technical guide, which says that when we approve a waiver, this says nothing whatsoever about your compliance with Olmstead. That means nothing. And a wide array of similar cases simply cannot stand because this is how states provide home and community-based services.
Mr. Rose, could I ask you to back up and go back to the last question I was asking Ms. Mathis about what happens to your case if Section 1983 is not available for the particular provisions of the Medicaid Act you rely upon?
Of course, Judge, and depending on what the Supreme Court does with the Planned Parenthood case, we acknowledge that that could sound the death knell in our Medicaid Act claims. It has no bearing whatsoever on our Olmstead claim, which I think everyone acknowledges is the at least the lead claim.
Well, see, we're all pretty familiar with Talevsky and its St. Anthony echoes in this court, so we'll see what happens.
Of course, Judge.
Mr. Rose, under your theory, so as I take it, the regulations provide the state, I think we all agree, with an option, right, to define extraordinary care, and thereby, at least how, to the extent that it defines extraordinary care, to reimburse LRIs to provide that care, right? Under your theory, though, wouldn't the state have to do that under the ADA for everyone in your situation? In fact, wouldn't every state need to do that? And so how does the may become a must? And how do we navigate that?
The serious risk assessment under Olmstead is always going to be an individualized one. We know, and the district court found, that these 2 plaintiffs are at risk of institutionalization without that. The fundamental alteration prong is a macro, it views the situation globally. If the state does this, is it going to fundamentally alter its program given its need to provide this care to a wide variety of persons with different disabilities? The state had every opportunity to demonstrate to the district court, to this court, that requiring it to do so would fundamentally alter the nature of its program. At this point, it can't even tell this court, couldn't tell the district court, how many LRIs were providing attendant care to their loved ones prior to the change at issue in this policy, in this case. And
I see. So just so that I understand the where we are in the answer. So what you're saying is that the state has an obligation under your theory for every individual who's in serious risk of institutionalization, they need to define kind of extraordinary care and kind of reimburse under that scenario, unless they can prove that doing so would be a fundamental alteration. So they always have that kind of safety valve.
And if I could add to that, Judge, there's absolutely nothing in our argument that says that the state can't prioritize structured family caregiving or any other service to the extent that those services will ward off the potential for institutionalization. We've given the hypothetical of two-income households who might not feel the limitations of structured family caregiving as acutely as these plaintiffs. For those persons, structured family caregiving might be a perfectly viable alternative. And there's nothing in our argument that says that the state cannot prioritize that service over attendant care for persons whose needs can be met with that service. There's something supremely counterintuitive about the position that the state has taken, both in this policy and in this case. Ms. Carter and Ms. Knight are filling a gap that exists in Indiana because they have not been provided nurses. I think everyone acknowledges there's a nursing shortage that makes that difficult. And because their children simply cannot be attended to by someone who has not been specifically trained to meet their needs. They are the only available providers of critical services for their children's. And at the same time that the state is no longer allowing them to provide attendant care, it is more than happy, as the court noted, to pay a grandmother, an uncle, a neighbor, a family friend to provide the exact same services for whatever period of time is necessary when these women have to obtain a job outside the home. If and when nurses are actually located, it is more than happy to pay for those services at a rate much higher than what it's paying the plaintiff's mothers for whatever period of time is necessary to let them return to work. If either of the plaintiffs had fewer needs, the state would, such that they could be attended to by an untrained, unskilled caregiver, the state would be more than happy to pay for attendant care, either attendant care or a home health aide through the traditional Medicaid program for whatever period of time is necessary to ensure that these children remain safe. And it is not and has never been our position that there is not some aspect of normal parenthood, to the extent that such a thing exists, that these women cannot be required to do on behalf of their children. I think we have two things to look at so far as that's concerned. The first is that the state by regulation never pays for medically necessary services. It's the one that has reached the determination that the service levels these children are receiving is appropriate for them. But even putting that to the side, if we look at the state's home health policy, which is in the record as a part of docket 28-3, I think at ECF page 58, it specifically says that for children, at least children with significant needs, in single caretaker families, when that caretaker has to work outside the home, as my client's mothers will be required to do so, it is willing to pay up to 12, 16 hours a day in order to provide services to these individuals. Ms. Carter and Ms. Knight are filling a gap that exists in Indiana. This is not a case where they would simply prefer to be their children's providers. They're the only option that these children have right now.
Mr. Rose, for decades, home health care has been a great concern of state policymakers and budget officials because it can become a kind of black hole, taking in, particularly with entitlement, framed as an entitlement. And it's not surprising that there are serious efforts to try to get those expenses under control. As I understand, this injunction applies to these two families, correct?
That's correct, Judge.
So the state is telling us that there are something like 21,000 patients who've been receiving attendant care from family members, if I've got that right.
I think that might be the number of persons who have been receiving attendant care.
Attendant
not
care,
necessarily just from family members.
Okay, and I guess you heard what your colleague on the other side had to say, and it's hard for us, I think, or for the district judge to look at this case without thinking about fiscal consequences. How far does the logic of your position take the state in providing this care under the ATTC rates?
Judge, I've known Ms. Mappes long enough that I feel comfortable speaking for her. I think if you ask, I think if you ask the state, they would tell you that one of the problems that has given rise to its fiscal concerns is that FSSA may not have been exercising the oversight that it is entitled to exercise over individual service plans, whether those persons
I
are
thought I
served
heard
by
that at least laced into the discussion, and that's what accounted for the policy change.
whether the service providers are their parents, are their LRIs or not. Certainly we acknowledge that every waiver must go through this cost neutrality analysis, and at some point there's going to be, at some point something becomes no longer approvable as a waiver if it ends up costing more in the community than.
But we also have the problem of costing more compared to what, and
Of course.
if institutional care is the alternative, my understanding is that that's going to be much more expensive than any of these home care alternatives.
That's absolutely right, and I think the state's argument very much depends, somewhat tragically, on parents bending over backwards because they love their children. They do not want this outcome for their children, but they simply are not able to provide structured family caregiving. They're not able to serve as providers of that service. And just like any other community-based service, when the state fails to ensure the availability of providers, we are at that place where there is a serious risk, practically a certainty of these children's institutionalization. Could you
Tell us, and Ms. Mappes on rebuttal, perhaps you can tell us as well, but we're having this debate in the briefs about, in essence, whether federal financial participation will be available for the care and reimbursement that the district court has ordered. Is there, in our current record, any indication from federal authorities that they would not reimburse the court-ordered care here?
No, of course not, Judge. And even prior to the court order, the federal government has been reimbursing this care for years. We do believe that there's something incongruous about the state's position. Obviously, no one stands to benefit more than the state of Indiana by holding that the federal government is required to pay for this care.
Well, I understand that, but also, I mean, it's certainly a potentially powerful argument that the preliminary injunction is ordering the state to violate federal law.
And Judge, we don't think it is. Obviously, we agree that the preliminary injunction compels the state of Indiana to act in contravention of its current H&W waiver document. If the state really is concerned about the potential loss of federal funding, and again, I don't think there is any realistic concern about that issue, it has the ability to cover its bases by amending the waiver document in order to ensure.
Or by Section 250 of the regs?
Sorry, Judge?
By Section 250 of the regs?
And or through if that's the regulation requiring
about court orders.
For court-ordered services, certainly. And we think that regulation is obviously directly on point. We've tried to address each of the state's arguments that it is not by citation to decisions from the Health and Humanity Services itself applying that regulation to situations not contemplated by the state.
So I guess that raises a good issue with regard to 431.250. Looking at actually the paper copies of it, which I think is helpful when you look at some of these things because there's so many subtitles. One of the points that the FSSA makes is that provision falls under Subpart E, which talks about fair hearings for applicants and beneficiaries. And certainly nothing in the federal regulation publications when the predecessor of the rule was first proposed, adopted, when the amendment was adopted, nothing there indicates an intention to have this regulation go outside of the public fair hearing regulations. I guess two questions. Number one, what is your best argument that it does have that effect? Because we couldn't find any, at least circuit court cases that recognize that. And number two is, assuming that you're wrong, does it really matter here?
The answer to the first argument is that we did cite to the court an administrative decision by HHS applying that regulation to circumstances that did not arise through the administrative appeal process. And in fact, I think if I don't believe the case law cited by the parties, Heckler and the Illinois case, while obviously concluding that the services in those particular cases were not reimbursable, I don't believe that those arose under the through the traditional appeal process either. And the answer to the second question, which does it matter? I don't think so, Judge. Again, no matter what the regulation means, I don't think anyone views the loss of federal funding as a realistic eventuality here. The feds have been paying for this for years. The state has not cited, as we noted in our brief, to a loss of funding that happened after Bontrager issued, after BN issued. It's not new for provisions of either a state plan or a waiver program to be invalidated. And I think it is fairly uniformly accepted that when a court orders you to continue providing those services, the federal government will continue to reimburse those services.
So you said that the CMS approval specifically states that the approval does not address kind of concerns or the state's obligations under the ADA, right? Is there a particular site for that?
Judge, that's verbatim from the CMS technical guide that it disseminates to the states. CMS's role in approving a waiver is to decide, does this comply with the Medicaid Act? It has no role in deciding, does this comply with the ADA, with the Rehabilitation Act? And as I say, it is explicit about that.
Is it correct, Mr. Rose, that before this latest policy change under the, I think is it the A&D waiver that existed before?
It was the A&D waiver.
And the state was providing services that were not necessarily compliant with that
That's correct,
waiver,
Judge.
and federal financial participation was provided for those services, correct?
There's certainly nothing in the record to indicate that the federal government stopped paying for those services. Very briefly, the parties have briefed what we view as the shortcoming in the relief initially ordered by the district court. The district court obviously felt itself initially hamstrung by the fact that the federal government had not approved the waiver program. In so doing, it issued an initial injunction that I think everyone agrees, or at least the facts demonstrate, was not adequate to remedy the Olmstead violation itself. we think that the relief has to be modified to something similar but not identical to the state pending appeal. As we indicated in briefing, we also think there are problems with the district court's determination of at what point skilled nursing, at what point my clients providing services will actually give way to skilled nursing. So we think that the relief has to be modified here, but in all other respects.
If I understand your position, Mr. Rose, and help me, but you're pretty happy with the order that was put in place pending appeal, correct?
That's correct, Judge.
That corrected the biggest shortcomings that you were worried about.
That is correct.
And what's still at issue in your cross appeal is you're urging the court to order, in essence, an overlap where these mothers would be paid for training skilled nurses if and when they become available.
Both an overlap and the that's certainly one additional thing that we're still seeking. The other problem, I think, is that the district court decided that the ability of Ms. Carter and Ms. Knight to continue providing services goes away the second that Ms. Carter, that ER gets 40 hours of home nursing, that GS gets 80 hours of home nursing. This might be a complete hypothetical because they don't have nurses yet, but those numbers were taken from what they had previously received during a period of time when their mothers were allowed to provide care. That says very little about the level of services that they need when their mothers return to work outside the home, as they will be required to do. So we think that
those concerns all sound fairly hypothetical at this point.
And
the kinds of things that could be addressed by the district court while the case is still pending there.
And they very well may be. And what we did urge in our briefing is a remand to the district court to determine, to redetermine the appropriateness of those 40 and 80-hour numbers.
Thank you.
Thank you, Judge.
Thank you, Mr. Rose.
Thank you.
Ms. Mappes, we'll give you 2 minutes.
Thank you, Judge. I'd like to start by just pointing to a couple of record sites to respond to what was discussed, and then a couple of argument points. About your question for yearly salary, I can point to some record sites, the plaintiff's mother's affidavits at docket 28-7, paragraph 27, and docket 28-8 at paragraph 30. One of them, for example, says, I make approximately $2,000 a week. So that is translated into her take-home pay. I would also like to point again to Paul Bowling's declaration at docket 38-4, paragraph 6. He specifically talks about the fiscal impact and the number of individuals who were receiving.
Thank you.
LRI provided attendant care, and he notes that attendant care services expenditures were projected to be $172 million for fiscal year 2024 for 1,622 recipients, which is an increase of 195% from the year prior. Judge Hamilton, you had asked about federal financial participation and whether there was any indication that it would not be paid. There's not any indication that it won't be paid, but there's not any indication that it will. Our view is this is a legal question and not a factual question, and this is answered by Vaughn, right? In Vaughn, recall that plaintiff wanted the ability to self-direct her care. That was not something that was allowed under the existing waiver, and just as that was outside the waiver and the court specifically said in Vaughn the state does not have to fund this itself, it would have to go outside of the waiver. We believe that analysis in Vaughn answers this question and says the state does not have to provide some non-existent service out of its own dollars when the Medicaid program does not allow for that.
In Vaughn, if I recall correctly, that was the injunction ordered the state to pay somebody about 50% higher rates than the Medicaid program allowed, right?
Maybe I don't recall that.
It was way out of bounds as an injunction goes.
I appreciate that, but the court's description was this is outside the waiver and the state is not obligated to pay it itself, and we believe that analysis dictates the outcome here.
Okay.
I see I'm out of time. Thank you very much.
Ms. Mappes. Thank you, counsel. The case would be taken under advisement. Our next case this morning is Lindsay versus Neal. So we will start with Mr. Leoli? Leoy, okay. Whenever you're ready, sir.
Your Honors, may it please the Court. My name is Sam Leoy, appointed counsel on behalf of Stephen Lindsay. There comes a point when justice delayed is justice denied. That happened here. Stephen Lindsay's post-conviction relief petition has been idling in a state court for over 6 years. That delay is inordinate, unjustified, and attributable to the state. Indiana has failed to move this case forward toward a resolution.
Mr. Leoy, has there been any activity at
Still
all?
no, Your Honor. Still no. So after repeatedly facing state-imposed roadblocks and his motions lingering without any prospects of the case moving forward, to this day, as Your Honor just pointed out, Lindsay decided to take his case to federal court so that it could finally be heard. This court's case law confirms that Lindsay made a reasonable decision in light of the unreasonable circumstances that he faced. Under this court's precedence, then, his exhaustion requirement should be excused, and this case should be remanded to the district court for further proceedings. I welcome this court's questions. But otherwise, I can continue to dig right into it.
Well, let me ask this. Do you think we ought to be touching on this appeal the merits of the ineffective assistance of counsel theories?
No, Your Honor. As I pointed out in the briefing, I think the right course of action, since no court has yet weighed in on any of the substantive issues, is just to remand this for the district court to decide in the first instance. And as I pointed out, Your Honor is in the COA only pointed out a few of the issues in his federal habeas petition. He has a lot more, and I would say a lot more that are weighty and worthy of consideration.
Could I also ask you, in the state court docket, looks like in December of 2021, Mr. Lindsay moved to amend his petition.
Yes, Your Honor.
I haven't done a close analysis. I don't know if you have, to see what were the amendments about.
I haven't done the full compare and contrast, Your Honor. My understanding is the basic facts were the same. He added some things and added some substance to it. There's a lot in his petition, so it's a lot to kind of follow, and it's hard to run the red line on it.
Okay, and I would be remiss if I didn't ask you, you think the delay here has been unreasonable. When do you think it became unreasonable?
Yeah, good question, Your Honor. I mean, my position, as we briefly pointed out in the brief, I think it would have been reasonable for Mr. Lindsay in December of 2020, before he was erroneously appointed counsel. I think at that point there was an inordinate delay and nothing had moved forward. I obviously think several years later, after still not much progress towards a resolution, it's definitely inordinate delay at this point as well. But I think that was a good kind of earlier marker of when it was inordinate.
Mr. Leoy, the appellee talks about the general rule that a plaintiff or petitioner has an obligation to pursue their case, to move the case along, and it seems like we have these long gaps, right? That Mr. Lindsay would have had some opportunity, if he wanted to file another motion, and who knows whether that would still be pending.
Right.
For another status hearing, or kind of figuring things out, or saying, hey, look, I'm still out here,
Right.
by the way. And after November of, is it 2019, we don't really see much of that. And I wonder how you would respond to that argument.
Yeah, my response is, at a certain point, enough is enough, and I don't think this court would encourage pro se litigants to repeatedly file motions every few months if they have not heard from the court. I'll point out that Mr. Lindsay did file a motion for a status hearing, or a hearing, and then he filed another motion, asking for the court to rule on that and for status on all of those things. So I think he did enough. He tried to prod the case forward. It's on the state to, rectify the impasse that happened later on in the court, and the state court and the state prosecutors have done nothing to move the case forward, and I don't think it's reasonable to impose on a pro se litigant to repeatedly file more and more motions.
Counsel, is there anything in the record that shows that Mr. Lindsay himself, because of COVID lockdowns and facilities, was impacted in his ability to move the case forward? Is there anything in the record about that?
Nothing in the record, Your Honor. I mean, I have a pretty limited record, the same record this court obviously has, and there's nothing that says that he was impacted, but I think it's reasonable to assume that he could have been impacted. I know a lot of library services were down in prisons during this time, and I think that kind of cuts against the district courts and the state's argument that the COVID lockdown would have justified this delay. I think just the opposite. There's reason to say that it's unreasonable that the state was tardy on a lot of motions when Mr. Lindsay was clearly doing all he could from prison, during COVID to move the case forward, and the state could not do anything.
Let me ask you, you asked for an alternative form of relief for us to remand for an evidentiary hearing on the delay, whether it was inordinate. What would that hearing look like in your view?
Good question, Your Honor. I mean, obviously, I think it would be helpful to get a full picture of all of the record documents from the state court as to what was going on. But just taking a step back, I mean, my primary relief requested is for this court to just go ahead and hold that the exhaustion requirement is excused. I think regardless of what that hearing would show, I think it's pretty clear at this point that the state proceedings were ineffective and there's no need for the hearing. But, if this court were inclined to rule against me, I think I would prefer that they didn't do that and they had a hearing in the district court rather than that. But it's also possible they could get more understanding of what was going on with the state proceedings, why the court ruled the way they did, maybe more understanding of how COVID might have impacted the state court at that time. But again, I don't think the court needs to do that to rule in Mr. Lindsay's favor.
And along those lines, all courts were impacted, particularly in the spring of the COVID year 2020. The district court here was closed for a while.
Right.
Do you know when it was that the Porter County Court kind of closed due to COVID, and when it started holding proceedings again?
I don't know the exact timing. I mean, I assume it was probably around the time of March 2020, which was well after a lot of these motions were filed. I know there's a couple of the orders that were cited between the two parties. I'd have to go back and look. I think one was in August of 2020, and I don't recall when the other one was. But obviously, the state court systems did try to move cases along. After there were brief delays, they made it a priority to make sure that cases moved along, and this was just not one of those priorities. And if I may, I think I would just like to reiterate what I think are the two biggest defects in the district court's order and what I think potentially led to the contrary decision that it reached. The first was the factual mistake by the district court. I mean, it might seem like just a technical error, but I think it's a lot more than that. The district court, when it was reading the record, in all fairness, it was probably reading the record quickly, and it thought that the district court or the state court was responding quickly in December 2019 to address these issues. But I think it's a pretty fundamental mistake that it was actually in December of 2020, a whole year later. So these were not quick actions. And it also showed that there was not appointed counsel for an extended period of time. It was for a very short period of time, and I think that might have perhaps influenced the district court's decision. And then I think the legal mistake by the district court, respectfully, was the whole issue about appointed counsel and whether that somehow mooted all of the prior actions. I don't think that's what Indiana law requires. No one ever represented to Mr. Lindsay that his prior motions that he filed and that were still relevant were mooted. So I think those two mistakes are probably the two biggest, and I think those two alone might explain the district court's prior decision. And if I may add a third, I think the fact that Carter and Evans, two of the leading and most recent decisions by this court, were not cited by the district court, and the state, for its part, hasn't really engaged with those decisions. And I think that's because those are controlling in this case and lead to reversal here.
So, Mr. Lloyd, let me ask you about what I will call the delicate federalism part of this, which is, if we agree with you for any form of relief, we will be saying to the Indiana state courts something fairly strong about how they need to manage these cases. What do you think that message should be? How specific? How intrusive?
Thanks for the question, Your Honor. I would say this court can do something similar to what it did for Wisconsin in Carter and what it did for Illinois in Evans, and it's making clear to Indiana that once there's been an inordinate delay, there is an obligation on the state court to move the case forward, unless, of course, they are fine with the petitioner, opting out and moving into federal court. So you can make clear that this is the consequences if there's not more action by the state court or state prosecutors to move the case forward. I don't think anything stronger than that is required, but I think it would be a helpful reminder for the Indiana State Court that there is an obligation to not let these cases languish.
Should we frame an opinion, if we agree with you, in terms of anything specific, like a year of inaction, or 2 years of inaction, or 4, 5?
I think, Your Honor, I don't think you need to make that decision. I think the answer is clear in this case that 6 years with little to no progress is enough. I think this court can point to some of the other cases and say, here are other instances where we found a delay was inordinate. Obviously, it's a little bit context dependent on, what movement is happening in the case, but you can make clear this utter lack of movement and this extremely long period of delay is inordinate and thus ineffective.
Counsel, I read Carter, and I think the judge in that case called it tragic and extreme.
Yes.
But in that case, you had I'll call it the complicity of the appellate court granting something like 10 plus extensions.
Right, Your Honor.
And so that feels much more extreme than what happened here. So I don't, what's your best argument to say that Carter should apply? Because I see a very different set of facts here.
Right, Your Honor. I'd agree that the facts are different, and I think the other distinction there was that there was a shorter sentence, but I would say both the principles underlying Carter are relevant here, the alarm bells that should be ringing in the state court and for the state prosecutor to break up the impasse, that's still relevant here. And I'd point to the court's decision in Evans, which is also a different set of facts than this case, but it shows that little to no progress or repeated delays over a long period of time, those would be attributable to the state. And I think that's the same thing that happened here. And so even if the facts are not the same in Carter and Evans, I think this is just another set of egregious facts that this court can correct, or at least that this court can say is ineffective.
Mr. Leary, with regard to the appointment of counsel by the court and then the subsequent motion to withdraw, the motion to withdraw on its face, the only grounds that it stated was that, that Mr. Lindsay never wanted an attorney. Is there anything in the record that would suggest that the motion to withdraw was based upon, a fracturing of the relationship between counsel and Mr. Lindsay? Did Mr. Lindsay ever want an attorney in this case, to your knowledge?
To my knowledge, no. He reported from the beginning in his affidavit of indigency that he did not want counsel. I mean, respectfully, Your Honor, hopefully myself excluded, he had some bad experiences with counsel that he had in the past, and I think his preference was to move the case forward on his own. I don't think from my understanding, I don't know how much of this is in the record, I don't think he felt very excited about the appointment of counsel and the responsiveness there, but I don't know that how any of that is in the record. I think the motion to withdraw just says that the appointed counsel reached out to Mr. Lindsay, pointing out that he didn't ask for counsel and confirming whether he did, and then we see the motion to withdraw.
It was almost immediate, right?
Correct, Your Honor.
So, okay.
If there are no
Anything else
further
you'd like to add?
questions?
No, thank you.
Thank you.
Ms. Murray.
May it please the court. This court should affirm the dismissal of Mr. Lindsay's petition for a writ of habeas corpus because he has failed to exhaust his state court remedies as required, and that failure should not be excused. Mr. Lindsay has an ongoing state post-conviction proceeding, and that state process has not been ineffective. Mr. Lindsay has been ineffective at prosecuting his claims.
What else was he supposed to do?
He has a number of tools in his tool belt that he can use at this time. He could, if he has discovery issues, which he has indicated he is still at this time not ready for an evidentiary hearing. He would like additional discovery conducted. He could move Trial Rule 37 to compel discovery. Mr. Lindsay notes that there's been discovery objections on the record, but that does not mean that court intervention is necessary. A party may simply acquiesce to an objection made.
Has a hearing date been set?
A hearing date has not been set. I'd like to be
And
clear.
he asked for that in 2019, correct?
He asked for a hearing in August of 2019. He asked for a status update in November of 2019.
Those remain pending, correct?
Those could be viewed as still pending, yes. But that is a red herring whether or not those issues are still pending. What matters is whether Mr. Lindsay has been deprived of an effective state court process, and he's not automatically entitled to an evidentiary hearing. He points to a rule.
But isn't he entitled to a ruling on his motion for an evidentiary hearing?
It is incumbent upon Mr. Lindsay to move the case forward. That is a matter of...
I just want to make sure I understand. So what you're saying is that Mr. Lindsay filed a motion, and it's on the docket, and it just sits there, and the court has no obligation under its ethical obligations or whatever statutory obligations it has to address and rule on the motion.
There may be some obligations to rule on the motion, certainly, but it has not become an issue at this time because Mr. Lindsay has repeatedly indicated that he is not yet ready for an evidentiary hearing. That motion is best viewed as Mr. Lindsay notifying the post-conviction court that he would like an evidentiary hearing. In post-conviction proceedings in Indiana, they often, particularly in a pro se context, proceed via affidavit instead of an evidentiary hearing. Or a party will frequently move for summary judgment, and cases are handled that way rather than holding an evidentiary hearing. So Mr. Lindsay's motion is best viewed as notifying the court that he would like his case resolved that way, but that was in 2019 was the only time he has ever mentioned a request for an evidentiary hearing. He has not renewed that request. He amended his petition in December of 2021. To your earlier...
How many times does he have to... I mean, frankly, we see plenty of, as I'm sure you do, plenty of pro se litigants who bombard courts with repetitive requests, futile requests. Here we have somebody who asked politely once, no action for 3 months. He asked again for the status update, and that was more than 4.5 years ago.
He then amended his petition in December of 2021.
Anything meaningful in that?
Yes, it was a very significant amendment. He had multiple new claims. I believe it's D, E, and F that were substantive claims, brand new, and he had numerous new supporting facts to support his prior claims. This is a very, very...
And how did the court react? It allowed him to amend. Did it take any action to move the case towards resolution?
It did forward that petition to the prosecutor's office. The prosecutor was not required to file an amended answer at that time. However, we see that between the amended petition and the time of the amended answer, there was a new special prosecutor appointed, and they did ask for permission to file a belated response, which was granted during that time. A new special prosecutor certainly may have a different view of the case and want to file an answer at that time.
Can I ask, I was just kind of mystified, what's with all the special prosecutors in this case? And they kept declining.
There have been 3. The first did decline appointment. The second was on the case from August of 2019 into, I believe, May of 2022. And then there was a new special prosecutor at that time. The second special prosecutor stated that he wanted to limit his practice, be a bit closer to home, and so that's why he asked for relief from that appointment.
Why isn't this being handled either by the AG's office or by the prosecutor's office?
The prosecutor indicated that he was in litigation with the original prosecutors for Mr. Lindsay's case, and he did not feel comfortable responding to those claims, so he did ask for relief from that appointment.
I see. Okay.
It is Mr. Lindsay's burden alone to move his case forward. The question of who is the burden to move a case forward in a state post-conviction proceeding is a matter of state law that may not be second-guessed in a federal habeas proceeding, and state courts have been very clear that it is Mr. Lindsay's burden to move his case forward. He's taken no action.
Can you point us to the provisions in the Indiana trial rules or the post-conviction rules that give him the tools that you think he has failed to use?
Yes, Your Honor. He can move for summary judgment, which he has not done. He can utilize the post-conviction
How
rules.
could he possibly move for summary judgment on this record?
He may submit evidence, and that he can submit affidavits, depositions, parts of the record, and then move for summary judgment if he would so desire, or if he would like additional discovery, as he is now requesting. He has indicated now he is not ready for an evidentiary hearing. He would like additional discovery. He can use Trial Rule 37 to compel discovery.
Counsel, has Mr. Lindsay served any discovery on the state? I'm a little confused by this limited docket that I see here. You know, he asked, there was a motion requesting discovery filed in January of 2022, and the state appeared to respond to that, and then the state issued discovery on Lindsay, but then did Lindsay serve discovery on you all?
He has asserted that he has done so. Most discovery in Indiana is done informally and is not necessarily documented on the record. We do see that some discovery was documented in 2022. The parties were actively litigating at that time, and Mr. Lindsay has taken no action since September of 2022. So he has indicated that he has served that. I have not confirmed that with the prosecutor, but he has certainly asserted that he has served some discovery on the state.
And has the state answered any discovery?
We can see that the state has answered some discovery. They did object to his request for a particular personnel file. But again, these are routine processes that occur when litigating these claims. Certainly, just because a party has objected to discovery does not mean that the state court is under an obligation to step in at that time. There's a mechanism for doing so, and it is Trial Rule 37, which is a motion to compel.
So this discovery that Lindsay issued on the state, when was that? So the case, I'm just trying to figure out what's happening in this case, because there was very limited here in this state court docket. And there's assertions in the briefs about discovery ongoing, but without any indication of what that is.
Certainly, and again, most discovery is done informally. It's not necessarily noted on the docket, but we can see in 2022, the state responded to Mr. Lindsay's discovery in July 8th of 2022. The state filed a notice of discovery and a discovery request in August of 2022. And Mr. Lindsay filed answers to interrogatories and production requests and an objection to the state's request for production and discovery in September of 2022. Those answers to interrogatories also indicated that he was not yet ready for an evidentiary hearing at that time. His research was ongoing. He stated that he may yet identify witnesses to support his claims. His claims continue to morph and amend, and that makes sense when we have such a large record. Like this case, this is a murder conviction, a month-long trial. There are over 12 volumes of transcript. There are over 300 exhibits. It will take time to go through this record. Mr. Lindsay.
That doesn't sound that extraordinary, frankly. We see a lot of habeas cases out of murder cases.
It may not be for someone who's regularly litigating, but for a pro se litigant, it will take additional time. We see even now Mr. Lindsay has presented claims that have never been presented to the state court. One of the claims identified by this court, ineffective assistance of counsel for failing to hire a blood spatter expert, has never been presented to the state court. He mentions blood spatter expert in the context of ineffective assistance of counsel for alleged prosecutorial misconduct, but that is a very different claim than the one that he is bringing in habeas.
Ms. Murray, do you see any potential for a hearing on an evidentiary hearing in which the district court would examine the circumstances and reasons for the delay?
Mr. Lindsay has only today identified things that may come out during that hearing. The delay here seems to be no mystery. Mr. Lindsay has taken no action on his case since September of 2022 and indicated that he was not ready for an evidentiary hearing at that time. This is much more in line with Cyphers with Lane. In Cyphers, there was an 11-year delay. In Lane, there was over a 5-year delay. And there, this court said that an evidentiary hearing was not necessary because all the petitioner need do is to act, to get his case back on track, Mr. Lindsay may do so. Mr. Lindsay may ask for an evidentiary hearing once more on his amended petition, something that's never been done. He can ask for a status update to say, I am now ready. I know that I've indicated I have not been previously ready to litigate these claims, but I am now. And he can say that at a status conference, in which case the case may get back on track. It is his burden to do so.
Does the court have any obligation here? State court?
At some point in time, the court may have some ethical, professional responsibility to manage his docket, but the Indiana state courts have been very, very clear that even though a court may have tools to help a plaintiff move his case along, it is under no obligation to do so. It said as much in Carruthers versus State, an Indiana Court of Appeals case from 2016. The Indiana Supreme Court said in State versus Azania that it is the defendant's burden to move his case forward in a petition for collateral review. This is unlike Carter's. This is unlike Evans. In those cases, we see significant actions taken by the prosecutor or the state court that hindered a petitioner's efforts to litigate his claims. We have no similar action here. In Carter, there were significant extensions asked for. There was an issue with the transcript. There was a 10-month delay in acquiring the transcript. We don't have any issues with the record. We see Mr. Lindsay was able to provide the record to the district court here. There were 12 extensions requested by defense counsel in Carter, and then the state court also were granted extensions to rule. It's notable that in Carter, that is a Wisconsin court case, which is distinguishable from what we have here. This court has noted multiple times that Wisconsin has a unique procedure in which it combines post-conviction and direct appeal. The defendant there had pled guilty, and after 4 years, there was no review of any kind of his case. That is a very different situation than Mr. Lindsay, who has had direct review completed, and this is a purely collateral review proceeding. So
Ms. Murray, there's a case by the Indiana Supreme Court, In re Hawkins, 902 Northeast 2nd, 231, 2009, where, and there an ethical complaint was brought against a judge and a commissioner for delays in addressing post-conviction petition. There, the Supreme Court in Indiana said, flat out, Canon 3B9 requires judges to dispose of all matters promptly and efficiently. It is essential for all judicial officers to have in place procedures to ensure that not only that judges make a timely decision, but also that the order is correctly and promptly processed. So it seems to me that, the Indiana Supreme Court is recognizing, even in post-conviction proceedings, that a judge has some ethical obligation to keep things moving. And the question becomes, I guess to you, here we see a delay of 3 or 4 or 5 years. How long do you think is long enough for a judge to just sit on a case?
here, this court has noted in Lane and in Cyphers there was an 11-year delay. In Lane, there was a 5.5-year delay. And because the petitioner had the ability to put the case back on track, just as Mr. Lindsay has the ability to put his case back on track by filing motions, reiterating his requests.
So your position is that a court can do nothing in a case for 11 years and still meet the court's ethical obligations in Indiana?
The ethical obligations may be a separate matter. And certainly there is some duty on the court to adhere to those obligations and to ensure that it manages its court docket responsibly.
And so
certainly.
when a litigant files a motion, isn't it reasonable for the litigant to expect the court to actually rule on the motion or process the motion in one way or the other?
Not when he is indicating that he is not ready for the request that he has made.
What about the motion for requesting status, right, of previously unanswered motions? The court never addressed that.
You're absolutely right, Your Honor, and we can see what happened during that time. It took over a year for the state court to review Mr. Lindsay's case. We know that the COVID-19 pandemic hit during that time. There was 144 days between Mr. Lindsay's request in November of 2019 for a status conference and the time that the state court addressed his case in December of 2020, 144 days were told pursuant to Indiana Supreme Court orders because of the COVID pandemic. And then we
100,
know
how many, I'm sorry, how many days?
144. There were 4 different orders issued by the Indiana Supreme Court, one on March 23rd, 2020, one on April 3rd, 2020, one on April 24th, 2020, and one on May 29th, 2020. And in total, those told, I believe, 144 days of that time. So over a third of that time was told, and they recognized that there were going to be a backlog of cases, that it would take time to work through those cases, and certain cases were given priority during that time. Speedy trial requests, things of that nature.
Okay.
So it did take time.
One other question. The motion for leave to amend the petition that was filed on December 14th. Did the court issue an order granting that motion?
It did not issue an order granting that motion. It did forward that request to the prosecutor's office, and then it did allow the prosecutor's office to file a belated answer to that. So it seems to have acquiesced to that, and it would have been an error to deny that request because they are entitled to that as of right, that first amendment. So overall, we see that the state court process, it has not been perfect, certainly, but he is not entitled to a perfect process. He's entitled to an effective process. And we have the prosecutor who has been responding. He complains that they missed a couple of deadlines, and we see that the first answer, his first petition was not served on the state, and they answered within 2 weeks of being served.
Okay, thank you. I'm sorry.
Oh, forgive me. Thank you so much.
Thank you, Ms. Murray. Mr. Lear, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. And just a few points that I want to clarify for the court. So one, my friend on the other side mentioned that it was 144 days, before the court responded in December 2020. But I don't want the court to lose sight of the fact that its response was a non-response. Its response was to appoint counsel, even though that Mr. Lindsay specifically said that's not what he wanted. And then the district court has not otherwise, it's only been able to guess as to why the state court responded as delayed of a way as it did. On the point about ineffectiveness, my friend on the other side repeatedly focuses on state law. I think I have some quibbles with the state law itself, but I want to reiterate that this is a federal question of whether or not the proceedings are ineffective. Carter and Evans make clear that at a certain point, the obligation is on the state to recognize an issue. But on the state law itself, my friend on the other side points to laches cases, and I just don't find those persuasive for the context here. My friend's not saying that Mr. Lindsay unduly delayed the proceedings or prejudiced the side by failing to act in any way. Just the opposite. Mr. Lindsay's been repeatedly trying to prod the case along. The fact that he hasn't done even more to perhaps annoy the court and file repeated motions, I don't think should go against him. But again, to reiterate,
the state's best argument, at least in my view, Mr. Leoy, is in essence this the point that we heard that that Mr. Lindsay has indicated he's not yet ready to try the issues yet. What's your response?
Happy to address that, Your Honor. So the motion to amend, I don't think it restarts the clock in any way. As they point out, as the state points out, the rules specifically provide that you can leave to amend as long as it happens more than 60 days before the hearing is set. So that, at least to me, suggests that it's commonplace for the hearing to be set. There might be moving pieces beforehand, but that doesn't mean that you shouldn't set the hearing and allow kind of that structure in place to get everything ready before those proceedings. So I just don't think that the motion to amend should take away from the fact that the court failed to respond to a lot of motions beforehand, and it was reasonable then for Lindsay to think that the court was just never responding. I see my time is up.
Thank you.
Thank you, Your Honor.
Thank you, counsel, for the argument. And Mr. Leoy, I understand that you and your firm have been appointed. We thank you for your advocacy in this case. Take the case under advisement. All right, next case, United States versus Kerajianis. Mr. Luthen, whenever you're ready. Welcome back, Mr. Luthen. It's good to see you.
Good morning, Judge Lee. Good morning. May it please the court, Elliot Louthan on behalf of Nicholas Kerajianis. This appeal arises from the atypical context of a combined change of plea and sentencing hearing.
What's atypical about that?
That it is not the norm. In the vast majority,
I did hundreds of combined plea and sentencing hearings in the same courtroom that the Judge Pratt did in this case. It's perfectly common.
in my limited experience as a federal defender of the last years and speaking with colleagues who represent federal defendants across the entire circuit, my understanding is that's not the norm, at least in the circuit, although Judge Hamilton, you know the Southern District of Indiana
I do.
very well. And
There is
so,
nothing remotely unusual about this, and in fact, it can help a defendant by being able to see a pre-sentence report before he actually goes through with the plea.
point very well taken, Judge Hamilton. I think to that,
I would suggest you not focus on anything unusual or atypical or unfair about this process and focus on the merits.
absolutely. In terms of the issues that we've raised and the merits of those issues, there are three issues: 2 Rule 11 violations and 1 claim of breach. I separate the first Rule 11 issue concerning the sentence reduction appeal waiver from the latter 2 issues because it provides the simplest and narrowest path for relief. The court does not even need to address the latter 2 issues because any of the 3 provides an independent basis to vacate and remand. We think that first Rule 11 issue is the easiest way of doing so. Rule 11 demands clarity. That's what the court said in Galladay. And here, the district court didn't mention the sentence reduction appeal waiver.
So Mr. Louthan, I understand that obviously this would have been much cleaner if that had been addressed explicitly. It was in the plea agreement, which the defendant said he had read and understood. What is the best indication we have in this record that the right to appeal a denial of 3582C2 relief was important to
The defendant.
to Mr. Kerajianis at that time?
So we have a few points, Your Honor. One, the confusion in the record where they go off the record, right? The district judge begins discussing his appellate rights, then there's some confusion, pause, they go off the record, then they return to the record. And that, per the Supreme Court's discussion in Lee, I think provides, quote, contemporaneous evidence that his appellate rights matter to him and his collateral.
Appellate rights in general, no doubt, but the specific omission you're challenging here is the 3582C2 appeal, right?
That's right.
So, okay, keep going.
And so that provides evidence that his appeal rights and collateral relief rights matter to him. And then number 2, we have his letter that he filed after sentencing where he expressed confusion and asked the court for help and to vacate his plea. And in there he mentions, among other things, that part of why he pled was so that he could, quote, modify. And we construe pro se filings liberally in favor of the litigant. And it makes good sense that would be his strategy. If I were representing him in the district court and he doesn't have much of a defense, right? He's gonna plead guilty. We look and say that these meth guidelines are harsh, but you have a potential shot down the road, given the discourse around the meth purity disparity, of potentially getting a guideline reduction. And and then lo and behold, we have the Sentencing Commission a few months later proposing those very amendments. And so,
Mr. Loughton, right after the break that you mentioned on page 26, the court then kind of spells it out, doesn't she? The judge says, so you're waiving the right to appeal, and you're waiving these post-conviction proceedings, but there's some exceptions. And let me talk to you about them. And one exception is that the government will not prevent you from filing a motion back here in the district court, right? And so the court says, look, you're waiving everything. You can do a couple of small things. One is you can file a motion in a district court, right? Why doesn't that adequately inform Mr. Kerajianis of the fact that everything else is waived?
Two points of response around one doctrinal and one based on this specific transcript. Stepping back doctrinally, Rule 11 contemplates a two-way street. It's not only that the district court must inform the defendant of the whatever Rule 11 provisions that issue, but that the district court must also determine the defendant understands. And so it takes into consideration the defendant and his or her knowledge.
You know, as I read the transcript, counsel, I think she was trying to ensure that he understood. Reading pages 26 and 27, that's how I read the transcript. She was concerned, and she was fulfilling her obligation under Rule 11 to actually go further and walk him through. That's how I read the transcript.
I read it the same way, Judge Maldonado. And so to get to that second point, I think what happened here is there's no ill will or malice. I think this was just an oversight and a misstep. If you pull the plea agreement itself, and specifically where it concerns his Part 8, it's Appendix 19 to 20, it's pages 12 to 13 of the plea agreement. What I believe the district court judge did was specifically walk through each of these paragraphs, and you can see how each question in the transcript relates to that paragraph. And so when it comes to the district judge, to your point, Judge Maldonado, of trying to ensure that he understands everything here and ensuring that he is informed, I think what happens is there's just the omission. And the final sentence of paragraph 27B, which concerns the retroactive sentencing guideline reductions, was missed. And she looked at it and saw, oh, he can file such a motion, and she tells him, but she misses, and understandably so. There's a lot going on in these hearings. Mistakes happen. That the last sentence says, furthermore, should the defendant seek to appeal an adverse ruling of the district court on such a motion, this waiver bars the appeal. And then that final sentence was not conveyed to him in the change of plea hearing.
Would it be a sufficient remedy here, Mr. Louthan, to say that if and when Mr. Kerajianis seeks relief under 3582C2 and is denied, that the appellate waiver would not be enforced? We've got several contingencies out there.
Sure. Judge Hamlin, I think that would be sufficient relief on the first issue.
Mm-hmm.
But ultimately, that doesn't remedy issues 2 and 3. And so if that was the remedy provided by this court on the first issue, then there would be a need to address the tandem of
Mm-hmm.
issues 2 and 3, because ultimately, Mr. Kerajianis takes the position that his plea was unknowing, and he is looking to vacate that plea. I recognize I'm into my rebuttal, and I'd be happy to address any of the court's questions on issues 2 and 3.
Well, yeah, I guess. What's your best case? We're on plain error review on all of these things.
That's right.
And what's your best case that where the district court offers a different guideline calculation? That it's a breach of the government to fail to object?
The best case is Cruz in the Third Circuit, and where there's the benefit of the plea agreement is that the parties will present a united front on what his offense level should be. And I know the government filed the First Circuit case, Carvajal. The reason why that case is different is that in this sort of context, there no doubt both parties are walking a fine line, where if the district court asks a factual inquiry, you have an ethical duty to answer that factual inquiry accurately. But to take the legal position that an offense level, an enhancement applies that was not bargained for, means that Kerajianis is not receiving the benefit of the bargain that he struck with the government.
Well, nobody objected, right?
That's correct.
So was defense counsel asleep at the switch, or did she understand that Tinsley had changed the double counting rule?
This, when I read through this record, Judge Hamilton, I see confusion. I see the defense counsel being asleep at the wheel. I think Kerajianis' post-sentencing letter is just echoes in that sentiment. His counsel did not do him a justice and took advantage of him.
All right, thank you. Mr. Clark. Good morning.
Good morning, Judge Lee. Colin Clark on behalf of the United States. I'd like to start out with the Cruz case, the Third Circuit case that my friend cited. In that case, the United States agreed that they had advocated for the guideline difference, which was not permitted by the plea agreement. That's essentially the main point of contention between us, and so I don't see how Cruz really helps him. In fact, the issue there was not the failure to object. The issue was the advocacy. And so the opening brief, at least, is styled as the silence is the breach. And every case the United States found, and there were many, said that an objection alone is not a breach. And to my friend's point, I don't believe that there's any case he's ever cited or any case in any of those cases that we cited that says the failure to object is itself a breach because of the Benchamal case from 1985, the Supreme Court case. So beyond that, I think this court would like to avoid a Rule 11 situation to address something else that was discussed, where district court judges act like they have a checklist of 15 or so items that they have to cover under Rule 11B.
Have you seen the bench book? All three of us have done that many, many times. And it's a checklist. So.
Let me clarify it. And I know that all of you have much more district court experience than I do. But while there are things that must be covered, to overemphasize those things and to underemphasize the importance of the discussion, the importance of reaching an understanding with the defendant, I think you lose something. In terms of whether this transcript shows confusion, it does not. It shows an off-the-record conversation between the defense attorney and his client and her client. Recognizing that it's generally a rule in post-conviction proceedings, we normally presume that counsel is effective, particularly on direct review before we've even had a 28 U.S.C. 2255 motion. I don't think it'd be in line with this court's precedent generally to presume misunderstanding. In fact, if we have a defendant who wants to ask a question, we should encourage off-the-record conferences to take a pause, slow it down, make sure that there's a full understanding.
Mr. Clark, can I ask you about this waiver on appeal of a denial of a 3582C2 motion?
Yes, Your Honor.
I have frankly never seen that provision in a plea agreement before. Is that important to the government?
It is.
And
it is, as I understand it, it is a part of our office's current standard plea agreement. However, because of this case, I don't think I'd be giving you too much inside baseball to say that we've had a discussion about whether we should have it going forward, but we believe that here it is valid and enforceable.
Well, it obviously was not addressed in the Rule 11 colloquy. And one option seems to me would be to simply defer a ruling on whether it's enforceable or not and wait, let that be decided if and when such a motion is filed, an appeal is filed, and the government then seeks to dismiss it based on the appellate waiver. Another option might be just to say, look, this apparently got past everybody. I don't know why the AUSA didn't speak up when this was going on. I don't know why the defense counsel didn't speak up when this was going on, but just go ahead and say now, this little niche of a waiver is not going to be enforceable in this case. Go forth and fix this going forward.
If I may first challenge the premise of the question, it was covered. This was covered.
Where?
On page 26 of the transcript, there's a general waiver to post-conviction proceedings, and the word proceeding includes an appeal, as we cited Black's Law Dictionary for that, with exceptions. And so we have a general waiver with exceptions to be discussed. And the applicable exception was the government agrees that this waiver will not prevent you, Mr. Kerajianis, from filing a motion back here in the district court to get that retroactive sentence reduction. That's on page 27. If the district court wasn't trying to follow the plea agreement, there's no other reason to have the words in the district court. The words in the district court show that the district court judge knew what she was talking about at the time.
But then just forgot to mention that that will be final and you won't be able to appeal from that?
Well,
that's reading an awful lot into that.
In the Stoller case, which we cited, it does permit implicit coverage of the issues in a Rule 11 colloquy. And so I believe it is necessarily implicit in what she said as a matter of logic. And you may not buy that, Your Honor.
I don't, frankly.
And so allow me
Nor
to
do nor do I buy your suggestion that mandamus is a sufficient or relevant remedy here.
Okay. Well, let me at least get back to the question you did ask, and that's what about the next step? And the Coleman case shows that there was an adequate substitute for the knowledge that if you find the transcript lacking. There's no suggestion that the plea agreement itself is defective in any way. It covers all the issues. Under Coleman, if you have testimony that the defendant read the plea agreement, discussed it with the attorney, and understood it, that is an adequate substitute for a Rule 11 violation such that there's no prejudice. Moreover, under Dominguez Benitez, the issue with prejudice is not whatever might affect positively Mr. Kerajianis' case, but he has to show by a reasonable probability that he would have gone to trial. There's no evidence in this record that he wanted to go to trial. Even his letter equivocates as to whether he wanted a trial. And so even if you take him at his word, and you shouldn't because the letter was not under oath and his testimony was and they conflict, but even if you do, he doesn't want a trial, and so there's no prejudice on that first claim. And so therefore, even if you take it all as true, there's no relief. And I was surprised that my friend did not address Coleman in his reply brief. As to the second argument, the court, not the probation officer, not the parties, has an obligation to calculate the applicable sentencing guidelines range, and I don't understand that there is any legal obligation to work off the PSR or use it as a guide. To require the district court to say that would be to require the court to commit legal error, as an unaccepted PSR is nothing more than a recommendation by the probation officer. And then
You think it would be a good idea to let the defendant know that the judge is going to look at that PSR and start with those guideline calculations?
The district court confirmed that the defendant read the PSR, and the probation officer explains that the calculation guideline is different from the plea agreement. It says that explicitly on page 4 of the PSR. And so at this point in these proceedings, we assume that what everybody's testifying to is accurate. And so if Mr. Kerajianis said that he read the PSR, we must, absent compelling evidence to the contrary, find that he read that there was the PSR and the plea agreement had a different guideline calculation. The methamphetamine argument, the sort of prejudice argument on this first claim, is it seems to be based on two contradictory showings. First, on the one hand, we have a novice, first-time federal defendant who does not intuitively understand the guidelines and doesn't know what he was waiving. Yet, on the other hand, we have this potential 3582C sentence modification strategy that stems from the hope that the federal government would soon address the meth purity sentencing disparity. That's on page 21 of the opening brief. That would mean that the argument is something like this, that Mr. Kerajianis, the 3582C2 appeal waiver is material to him because he foresaw in 2023 a possible change to the sentencing guidelines in 2025, possible retroactivity at a later time, and the possible need for an appeal after he was denied a motion after that. That is fundamentally inconsistent with the idea that he didn't understand what his 3582C2 rights were. And so I ask this court to simply take Mr. Kerajianis at his word in his plea agreement and in the transcript, something that is fundamentally different than the Sura case that my friend has talked so much about, that taking all of that as true, this was a knowing, voluntary waiver. Thank you very much, unless there are further questions.
Thank you, Mr. Clark.
Thank you.
Mr. Sullivan, we'll give you 2 more minutes, please, on rebuttal.
Thank you, Judge Lee. I'd like to address the fundamental tension into a question that you asked Judge Hamilton about the significance of the pre-sentence report, and to your point that these sort of hearings are common and there's a benefit for defendants in these combined hearing contexts, with it being that they have the pre-sentence report in hand. Here, that pre-sentence report and the significance of it was not addressed in the Rule 11 hearing. And Rule 11B1M, by its terms, encompasses that needing to spell that out, the significance of the pre-sentence report out, so that the defendant understands what is the district court's obligation to calculate the sentencing guidelines and what that obligation means. As a first-time federal defendant, it might seem counterintuitive to us that someone would not necessarily understand what a PSR does or what its relationship is to a plea agreement. But for a federal criminal defendant, we oftentimes are explaining to them the relationship between the two, and that the PSR takes precedence over the plea agreement. That's not necessarily clear to someone, and that the fact that the government flags, well, he said he read the PSR, he swore to that, sure, he absolutely read the PSR, but that doesn't mean he understood its relative insignificance to its relative significance to the plea agreement. And I think what is the fundamental tension is that if he understood the significance of the PSR, he would have spoken up during the sentencing. But he didn't. And that shows how there is an additional Rule 11 error, that his plea was not fully knowing and voluntary. And that had he understood the relationship between the two, he would not have pled under the confines of that restrictive agreement. And there's a reasonable probability that the outcome of the proceeding would be different. If there are no further questions, we'd ask that the court vacate and remand.
Thank you. The case will be taken under advisement. At this point, the court will take a brief 5-minute recess. Our next case is Christopher versus the United States. We will first begin with Mr. Leach, is that correct?
That's correct, yes.
Welcome to the Seventh Circuit, Mr. Leach.
Thank you. Thank you for having me.
Whenever you're ready.
In a case where Mr. Christopher was facing a 10-year mandatory minimum sentence for a crime involving a minor, and where Mr. Christopher's conduct involved an adult as part of an FBI sting, counsel's performance fell below a reasonable standard when he failed to raise an argument to dismiss this claim. Today, we ask this court to reverse for 2 reasons. First, the plain text of Section 2260A makes clear that in order to be convicted under the statute, a minor, and not an adult acting as a fictitious minor, must be involved. Under bedrock principles of statutory interpretation, when the language in a statute is plain and unambiguous, as is the case here, the court is bound to interpret that statute as it was written. Second, Mr. Christopher's counsel failed to research a roadmap provided by Dahl v. United States to dismiss the 2260A charge, as well as a circuit court decision in Jones that found the argument to very well may have had merit. Given that there was a reasonable probability that the outcome in Mr. Christopher's case would have been different had counsel raised this argument, the performance fell below a reasonable standard. Turning to the statutory argument, we should just first start with the elements of 2260A.
And Mr. Leach, I know that you're splitting your time, right?
Yes, Your Honor.
What are the particular issues that you'll be addressing versus Mr. Banks?
Ms. Banks and I are prepared to
Banks,
answer for all of those questions on both issues,
Great.
Your Honor.
Go ahead.
So turning to the statutory argument, we should just first begin with those elements. First, you have to be required to have been registered as a sex offender. Second, you need to commit one of the predicate crimes under the statute. And third, that crime has to involve a minor. The word involve means to contain as a necessary element, which I'll note the government didn't dispute in their briefing.
Contain as a necessary element?
Yes, Your Honor. Yes, to involve as a minor is to contain as a necessary element.
I'm sorry, I'm balking because I don't think you mean it involves a categorical kind of analysis, do you?
No, we, in the specific element, mean that there has to be a necessary element of a minor in the crime involved in the predicate crime considered under 2260A. And we think, and kind of in that perspective, we have 2256(1), where minor is defined as a person under the age of 18. So
why isn't it sufficient that the government has to prove beyond a reasonable doubt that the defendant intended to victimize a minor?
Well, I think the plain language, they could have used the word intended to involve a minor, but instead they use the word involve. They use the word to contain as a necessary element. Congress wrote on the page in the text that it needed to contain a minor, a person under the age of 18. And
I'm sorry, I'm involve as a necessary element. I'm balking again. I understand that there has to be some involvement of a minor in some way, but we know from the list of predicate crimes that a minor's involvement in those crimes is not always a necessary element, correct? A number of them can be violated vis-a-vis with the victim as an adult or a minor, right?
That's true, yes, sir.
So it could be coincidence.
I think I would just say to that perspective, I mean, even crimes in which we're talking about 2422, of which Mr. Christopher was convicted of, it could also involve an adult. And maybe this goes to a point, to Your Honor's point, adults can be contemplated even in child enticement statutes. They use attempt language when they're trying to do that. Even in circumstances where there's an adult member of FBI, like of law enforcement, that's contemplated under the statute, under 2422, Congress knows how to include that circumstance by using attempt language. The absence of the language, the attempt language in 2260A, is really clear and makes clear that Congress is trying to create a super added punishment in circumstances where a minor is harmed. And
But Mr. Leach, the statute 2260A says uses the phrase commits a felony offense, right, involving a minor, and a felony offense, at least under 2421, could include an attempted offense, right? The offense could be an attempted enticement.
yes, this
right?
is true.
So why isn't the language of the statute, by using the broad language felony offense versus, say, some other language, why isn't that broad enough to encompass attempt crimes?
Well, we think that it's just a separate offense here where we're considering a different element, right? They may have committed a felony offense, right, under that predicate crime, but that involving a minor is sort of the limiting nature of 2260A. What we see is that even in the case of 2422, of which Mr. Christopher was convicted, that he had not engaged with a minor. He had not involved a minor in his crime, and that attempt language is what puts it under the ambit of 2422.
And so Judge Hamilton pointed out that the mens rea would have to require a minor, right? Would have to involve a minor. In other words, the enticement defendant would have had to have intended the enticement to be directed to an actual minor, right? And so, is your argument that if Congress wanted to do that, Congress should have been more specific?
We think Congress needed to be more specific.
Can you point us to any other statute by Congress that would have included such specific language?
I could point you to any number of the predicate crimes here in which all of them except for I think it's 2244 and 2251A under 2260A include attempt language. Congress has a clear, well-trodden path to define and include circumstances when they are considering adult members of law enforcement. They use attempt language. In this circuit in United States v. Taylor in 2013, it's held the very same, that in order to be convicted under a crime like 2422, that you have to have attempt language in order to do so. That's what meets that ambit of the statute. And because 2260A didn't contain that attempt language, counsel was required to raise the argument here involving this. And we think that United States v. Dahl, which addresses a number of counter arguments under the Slaughter Court back in 2013, it makes it made it very clear a number of counter arguments as to why, which is one of the reasons why counsel was required to raise that argument. And we think that kind of the three elements here of those circuit court decisions that kind of miss this is that as we talked about, that mental state element is not there. It's not intending to involve, it's to involve, and there's no attempt language there. We think the presence of the word actual minor in other parts of 2256 also are not dispositive because it's confined to the context of sort of child pornography cases after Ashcroft Free Speech Coalition. And we also just think concerningly that the Fortner Court in the Sixth Circuit never even addressed Dahl, didn't cite to it, didn't acknowledge that it existed. And counsel under the Strickland standard is required to raise an argument. In cases in this circuit like Bridges and Coleman, this is a sort of intuitive argument looking at the elements of the crime. All we're asking counsel to do here is to review the elements, specific nature of the elements under 2260A here. But the fact that counsel failed to review those elements and raise an argument, under this when there was no other viable or even a viable, avenue for relief otherwise, it fell below that reasonable standard of performance.
Without Dahl, do you think you'd have a performance problem here?
Well, I think it's certainly possible, Your Honor. Certainly we're helped by the fact that Dahl exists, but I'd point to the case of Coleman where, there hadn't been at the time in which counsel was raising the argument that there was no, circuit court decision, and I think the specific language was that there was neither any court of appeals nor any federal district court that had found the challenge to have any merit. This court's own precedent in Coleman, I think, makes it clear that, even in those circumstances, that if there's a reasonable probability that the end result of the criminal process would have been a sentence of less prison time, as we think is the case here with a 10-year mandatory minimum charge, that should result in ineffective assistance of counsel. I'd even note with Bridges, I think, this court described the argument that the lawyer was required to make as counterintuitive and artificial. And yet,
well, that's the categorical method.
That's correct, yes, Your Honor.
Yeah. Could I ask you, Mr. Leach, what you all think the appropriate remedy is here, if we were to agree with you?
Yeah, I mean, from our perspective, we think the specific harm, habeas remedies are flexible and they can be tailored to that constitutional violation. We think here the violation here, the sort of most tailored remedy would be to vacate the 10-year sentence.
In order resentencing on the other charge?
Certainly that's up to Your Honor's prerogative. You could leave
That
the
would
sentence
have to be part of the remedy.
It's not required, no, Your Honor.
As a practical matter, it would have to be.
Sure. Yes. And from our perspective, we think that vacating that 10-year sentence is sort of tailored to the harm here. And yeah, certainly this court could remand for resentencing.
Or does the petitioner here want to just withdraw his plea and go to trial?
We've had conversations with, our client here, and what we think, at least from our perspective, is, and he was the one who raised this argument. I see my time's expired. Do you mind?
You can go ahead and answer the question.
He raised this argument pro se, and I think we're not necessarily going to say one way or the other how he'll proceed once we take below, but I think we think clear that his conduct didn't meet the statutory elements of 2260A.
Thank you, Mr. Leach.
Thank you.
And Ms. Banks, we'll give you the full 3 minutes on rebuttal. Mr. Simpson. Good morning.
Good morning. Good morning, Your Honors. May it please the Court, I'm Scott Simpson on behalf of the United States. Does the Sixth Amendment right to counsel require an attorney to make a long-shot statutory interpretation argument that 2 federal circuits have already rejected? That's basically what this case boils down to. This case, of course, includes a statutory interpretation issue, but we're not looking at that in a vacuum. Rather, the question here, it's Strickland. Is it the defense counsel below not making that argument? Was that an error so serious that defense counsel was not functioning as the counsel guaranteed by the Sixth Amendment? That's what Strickland says, and of course, was there prejudice? So on the statutory interpretation issue, this case illustrates that statutory language, statutory construction requires considering the work that a given word or phrase performs in a given statute. Section 2260A incorporates 16 other criminal statutes, some of which refer to children in whole or in part, some of which don't specify the age of the victim at all. Without that phrase, offense involving a minor, Section 2260A would impose an additional 10 years in prison on someone required to register as a sex offender who commits any offense under any of those 16 incorporated statutes. But the purpose of the Adam Walsh Act, which enacted 2260A, the purpose was to protect children and to prevent child abuse. So Congress was telling the courts, only to the extent the incorporated statutes involve children, the defendant is guilty of that additional offense under 2260A. In other words, the phrase offense involving a minor was meant to exclude those portions of the incorporated statutes that do not involve offenses against minors. Along the same lines, as Judge Hamilton observed earlier, you have the fact that the statute, the language is also saying that the mens rea element of the underlying offense must involve a minor. And defense counsel below, of course, was aware that Mr. Christopher's offense did involve a minor in that respect.
Mr. Simpson, in your experience, are federal prosecutions under these statutes to protect children, do they more commonly involve attempts to or actual victimization of actual minors, or more commonly involve these sorts of stings?
Your Honor, I think it depends on the statute. In my district, we see a lot of cases, a lot of enticement cases involving actual minors. I think in my experience, I'm just guessing here, maybe half, something like that.
Okay, thank you.
And again, that purpose of incorporating a prior offense when it involves a minor from that standpoint of the mens rea, the intent to victimize a minor, that also is consistent with the purpose of the statute to protect minors, to protect
Could I ask
children,
you,
to prevent child abuse.
given the debate about supplementing the record with Mr. Patton's post-judgment affidavit here, do you think we should assume for purposes of deciding this appeal that this was an oversight, or that was not a deliberate or strategic choice, and that that might be a factual issue that might have to be addressed later at some point?
Your Honor, rather than assuming it, I think the more appropriate conclusion for the court to take is that it doesn't matter, because we believe that counsel below did not violate Strickland by not raising this.
I think what you're saying, let's assume it was not a strategic choice and then address the merits.
It wouldn't matter.
I do need to ask you, what minor was involved in this 2242B offense?
It was not a minor. It was an FBI agent posing as a minor.
And so why would it be a long shot argument if, we have a provision that actually defined what minor is? You have you have two circuit court cases out there, but circuit disagreements between circuits happens all the time. There's no controlling precedent, and so you have the definition of minor. You have no controlling precedent. You have Dahl, which seems that reasonable jurists might disagree. So how is that a long shot argument?
No, I think, I know the defense attorney here very well. Very good attorney. I trust
He is well known to the court.
Yes.
I trust his affidavit. Obviously, I'm sure his affidavit is correct. But I'm just thinking about what he would have seen if he had looked into this. He would have seen Slaughter by get them mixed up, Slaughter and Fortner. I think Slaughter was the 11th Circuit, 2013. And then 2 years later, Dahl, District Court, disagreed with it. And then 4 years later, Fortner, the other circuit, going the other way. All of that, and I am answering your question, Judge Hamilton. I think we have to look at all the things that Mr. Patton would have seen if he had looked into this. Fortner going the other way, and all of that makes Dahl look like an outlier, look like an aberration. And then you have all of the things we've talked about in relation to the construction of the statute. You can't just look at the statute in kind of a knee-jerk way. Oh, that's what it says. It says minor. You have to look at, again, as I said, you have to look at how it fits into the statute. And I think if Mr. Patton had looked into it, he would have seen all of that. And it looks like a pretty, as I said, I think it looks like a pretty long shot argument.
Do you see the phrase involving a minor here? How would you define it, and do you see it as ambiguous or as broad or in some other way?
I don't see it as ambiguous, Your Honor. Again, because of how the statute is constructed, they're incorporating a bunch of other statutes, some of which involve minors, some parts of which involve minors, some parts of which don't involve minors, some of which don't specify at all, and so we have to obviously guess at what Congress was saying or logically deduce what Congress was thinking, but
let's stay away from guess.
So I'm guessing, certainly we have to logically try to deduce what Congress was saying, and they're trying to say, okay, we have all of these statutes. Some of them involve minors, some don't specify, and we're going after minors. Again, the Adam Walsh Act is saying we're trying to protect minors, trying to prevent child abuse. They're saying, okay, we're going after minors. And this is very subtle also, but it says offense involving a minor. The categorical approach was referred to earlier. It almost feels like looking at the statute on its face. Does this statute and does the mens rea under the statute involve a minor? So we believe that Congress was doing that, was saying to the extent these offenses involve minors, that's what's incorporated. And as I said, the defense counsel below would have seen all of that case law. Those decisions, those two Court of Appeals decisions, we think are thorough, are well-reasoned, unanimous. Both of those decisions unanimous on the part of each panel. And all of that, again, makes the district court decision look like an outlier. As this court has said, defense counsel need not pursue every non-frivolous issue under the sun. We don't want defense attorneys to be doing that. We don't want defense attorneys to be bringing in every possible issue for fear that they might later be held to have failed to provide constitutionally effective assistance of counsel. And we don't want district courts to have to deal with every possible argument. The Sixth Amendment does not give a defendant a constitutional right to an attorney who will push every conceivable issue. Now, finally, if I could just address, earlier there's been some reference to Coleman and I think Bridges as well. I realize that I'm talking to judges who are extremely familiar with both of those decisions. We think those are different. And in this respect, in both of those cases, the court was applying settled categorical approach principles to the issues presented. In Coleman, the court said the framework for that argument about drug isomers was already established, and in Bridges, the court said the building blocks of the argument about Hobbs Act robbery were already established. The problem in Coleman and Bridges, we suggest, was that that defense counsel had not seen that train coming. It was on the way with the foundations of those arguments already in place. And in fact, the court in Coleman noted that there was no adverse precedent for closing the viability of a Ruth-type challenge in 2013 when Mr. Coleman was sentenced. Here, very, very different with those two Court of Appeals decisions. Could I finish my two sentences? I see them.
Go ahead.
Thank you, Your Honor. In this case, in contrast, presents an issue regarding the correct interpretation of a single statute. There's no approaching train that we need to be thinking about here, no approaching train that we need to consider whether defense counsel should have seen approaching, and in fact, two appellate courts had already said that the train was going in the opposite direction. So we would urge the court to affirm.
Thank you. Ms. Banks, we'll give you 3 minutes. Welcome to the court, Ms. Banks.
Thank you so much, Your Honor. My name is Jalen Banks, on behalf of Mr. Charles Christopher. 3 quick points, Your Honors. The government mischaracterizes the performance issue here, ultimately, and the order of case law. So here, counsel had 4 cases, a universe of 4 cases to discover in order to consider and raise the straightforward statutory issue here. 1 case, slaughter, which this court is familiar with. A 2nd case from the First Circuit, United States versus Jones, which again held that the statutory issue here may very well be meritorious. 3, Dahl, providing a roadmap to counsel in order to consider and raise the straightforward statutory issue here. And 4th, Fortner, which simply reaffirmed the flawed reasoning of slaughter. Given that that was the 4 cases that counsel here had to research and discover, counsel's performance was deficient for failing to raise that argument with his client facing a 10-year mandatory minimum sentence and no other viable alternative defenses. Also, the government notes some subsequent case law that arose. And I would like to point out one thing, Your Honor. Lusk, one of the cases that came after slaughter in the 11th Circuit, actually cuts the other way. So in Lusk, it is clear that attorneys in the 11th Circuit were still raising the straightforward statutory issue in defense of their clients, despite the fact that the statutory issue there was foreclosed by prior case law. If counsel was raising the straightforward statutory issue in a circuit where the argument was effectively foreclosed, counsel here in this circuit, where the issue had not been addressed prior, should have raised the argument, again, where his client was facing a 10-year mandatory minimum with no other viable alternative arguments. Second, Your Honor, the government, again, would like this court to guess at the legislative intent that Congress had when enacting 2260A. The legislative intent, Your Honors, is not clear, but the plain text is clear and unambiguous. And, as Justice Holmes noted over 100 years ago, we must not construe a statute upon the speculation that if the legislature had thought of it, very likely broader words would have been used. Again, highlighting the fact that interpreting the words on the page is the cardinal rule of statutory interpretation. Third, Your Honors, I would like to turn to this point. The Dahl Court noted that the rule of lenity need not be invoked, again, because the statutory issue here was so plain and unambiguous. But at the very least, this is a close question. And as Justice Gorsuch noted on the rule of lenity, our distinctly American version of the rule of law seeks to ensure that people are never punished for violating just so rules concocted after the fact. Under our rule of law, punishment should never be the product of judicial conjecture. And so, ultimately, Your Honors, all told, counsel here had a straightforward statutory issue at their disposal that they omitted and did not raise, absent any other viable alternative arguments or defenses for their client, and a 10-year mandatory minimum that their client was facing, which prejudiced Mr. Christopher's case in several ways. And because of that, we are asking this court to vacate count 2 of Mr. Christopher's sentence, along with the 10-year term of imprisonment.
Thank you. Thank you to counsel for your arguments today. Particular thanks to the Federal Appellate Clinic at the New York University School of Law for taking this on a appointed basis. We will take the case under advisement. Thank you. Our final case today is Mendoza versus Bondi. Mr. Budzinski, is that correct? Yes, Your Honor. Whenever you're ready.
Good morning, Your Honors. Budzinski for Petitioner Santos. There are 3 issues today: standard of review, jurisdiction, and on the merits, hardship. Beginning with the standard of review, the hardship question here is a mixed question of law and fact, that is, application of law to undisputed facts. The Supreme Court in Guerrero-Las Prias held that these are reviewable questions of law. Questions of law are generally reviewed de novo. Respondent, citing the Supreme Court's opinion in Wilkinson, argues it should be the more deferential substantial evidence standard. And as respondent points out in its supplemental authority letter, the Third Circuit agreed on remand in Wilkinson. I, however, read the Supreme Court's opinion a little bit differently, as pointing out the obvious, that review of mixed questions in this context is already inherently deferential, because Section 1252A2 still prohibits review of agency fact-finding. In effect, applying the substantial evidence standard here would provide the agency with 2 layers of deference. One, on the facts, no review of the facts, and then deference on the application as well. And we do not believe that's accurate. The mixed question here is, as the Supreme Court says, reviewable as a question of law, and it should accordingly be reviewed de novo. Turning to jurisdiction, respondent contends that Santos's argument is merely factual, and his petition for review should therefore be dismissed. This is not accurate. There's no dispute that Santos's family members suffer from their diagnosed mental health disorders or the other relevant factual circumstances. The only dispute is whether these circumstances put us in exceptional and extremely unusual hardship territory.
Mr. Budzinski, there are points in your briefs where you do take issue with the accuracy of the immigration judge's factual findings, right? And so in those cases, given the standard of review issue here, should we just kind of assume the facts as the immigration judge found them and then apply the legal standard to that?
Correct. We cannot review the facts, so that's correct, Your Honor.
Okay.
Turning to the merits, Santos must show exceptional and extremely unusual hardship. Here he has 3 U.S. citizen children as his qualifying relatives. And exceptional and extremely unusual means substantially different from or beyond that which would normally be expected. The board has recognized that a strong applicant might have a child with serious health issues or special needs in school. However, the hardship does not need to be unconscionable, and not only applicants with serious medical conditions will qualify. Here again, we have 3 children. One has generalized anxiety disorder and separation anxiety disorder, and then we have 2 more also with separation anxiety disorder. The immigration judge noted that these were recent diagnoses and that they're not taking any medication. I don't view these as particularly relevant considerations. The timing of the diagnosis doesn't really change the fact that they have these disorders, and the medication is accurate, they're not taking any, but that's not the only treatment available for anxiety disorders, and they intended to pursue therapy. As the immigration judge put it, he stated this was the definition of anxiety that attends every family in removal proceedings. I view this as a bit of a straw man. It's not accurate if we assume every family in removal proceedings has diagnosable health disorders. And then on top of these disorders, we do have your more emotional hardship caused by separation from a father and financial hardship. Their mother alone is not going to be able to cover the financial expenses of their household. And then educational hardship, their father was the role model in their educational pursuits, and they don't believe their mother's going to be able to do that on her own. As it stands, this is pretty bad, but that's not all. Their mother, who of course would be raising them alone upon Santos's removal, suffers from post-traumatic stress disorder and neglect as a child. One would not normally expect the removal of one non-citizen to result in 3 children being raised by an undocumented, essentially single parent who is suffering from PTSD and neglect as a child, when those 3 children also suffer their own anxiety disorders. Respondent contends that Cabrera and Arreola Ochoa had equal or greater levels of hardship. In Cabrera, we had the son's speech therapy, spouse's anxiety, and the financial reliance on the applicant. Again, here we have the anxiety disorders of the children, and they're going to be raised by a mother with PTSD in addition to some of the other hardships we've discussed. And this doesn't sound equal to me, and the same can be said of Arreola Ochoa, where the applicant's partner had migraines and hearing problems, but the qualifying relative was in good health. Lastly,
Mr. Budzinski, let me just ask you, I mean, these are very difficult problems. In the first instance, on judicial review, if there's any degree of deference given to the weighing of facts, and it seems to me that there probably needs to be some degree of deference there. Can you point us to case law that would, in your view, compel a reversal? Let's say any reasonable immigration judge would actually have to grant relief here.
What I would point to is Andazola. It's an agency decision, and there's a dissenting opinion in there that called the case close. And there was a mother with a history of asthma, and no other health-related issues or hardships were there, and there were also some financial concerns. And this case here is much stronger. If that's a close case, this has to be exceptional and extremely unusual hardship. If there are no further questions, Your Honor, I would ask the court to reverse and remand.
Thank you. Mr. Markle. Whenever you're ready.
May it please the court, my name is Justin Markell and I represent the Attorney General. The court should dismiss this petition for review because petitioner's challenge to the agency's hardship determination is premised on a factual dispute. Although petitioner now argues that he's just arguing that it's undisputed facts being the law being applied to undisputed facts. That's not what he argued in his opening brief. In particular, he argued that the agency erred in its hardship analysis by finding the emotional hardship its children will experience to be medical hardship, by finding that children were and not receiving medical intervention or anti-anxiety medication, and by failing to consider the condition of petitioner's wife, despite the immigration judge explicitly stating that her condition was a factor to be considered. As the INA prohibits review of factual findings underlying the agency's hardship determination, and petitioner's argument is premised on a dispute of facts, the court should dismiss the petition for review. However, to the extent the court concludes that petitioner's argument is not premised on disputed facts, but instead just a challenge to whether the agency erred when concluding that the undisputed facts do not show exceptional, extremely unusual hardship, then the court should join the Third Circuit in finding that the appropriate standard of review is substantial evidence.
Mr. Markell, is that inquiry completely binary? In other words, do we have to say that it seems like there are times when the petitioner does challenge some of the factual findings, and then there are other times when the petitioner seems to argue that whatever the immigration judge decided doesn't rise to the level, or does rise to the level of hardship, and that that particular application was incorrect. Can't we just say, to kind of ignore the disputes with regard to the factual findings, since we're kind of working with the facts as the immigration judge saw it, and then consider the legal argument that petitioner's making as well, that the application was incorrect?
Of course, I would believe that's a judgment call for you guys, but the thing to consider is whether or not he meaningfully challenges the agency's determination on the undisputed facts. And arguably, he doesn't meaningfully challenge it because the primary thrust of his argument was based on these disputed facts. Regarding the standard of review, as the Supreme Court explained in Wilkinson, although the exceptional, extremely unusual hardship determination is a mixed question of law and fact, it's primarily factual in nature and thus deserves deference. Therefore, we know the standard of review is not de novo, because de novo is not a deferential standard at all. Rather, precedent indicates that the most appropriate standard of substantial evidence. And we know this by looking at other Supreme Court cases where the Supreme Court has looked at primarily factual, mixed questions of law and fact, and used the clear error standard of review that it applies to district court purely factual determinations. For example, in U.S. Bank, it applied the clear error review to the primarily factual mixed question of whether an individual constitutes a non-statutory insider for purposes of bankruptcy. And in Minoski, the court applied the same clear error standard to the habitual residence determinations under the Hague Convention for Civil Aspects of International Child Abduction. Consequently, of the various deferential standards of review, the court should apply the same standard it applies to other immigration-related factual determinations, and that's substantial evidence. That standard of review is specifically laid out in the statute at 1252b4b, and under that standard, substantial evidence review, agency findings are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. Another reason why it appears substantial evidence determination would be the most appropriate is that there's tons of precedent regarding the standard review for persecution determinations, which is also a highly factual mixed question of law and fact, where you're looking to see whether or not the harm rises to the legal definition of persecution. And all the courts review that for substantial evidence. So we would argue this is very similar to the exceptional, extremely unusual hardship determination. Lastly, the agency here reasonably concluded that petitioner failed to establish exceptional, extremely unusual hardship to his qualifying relatives. The burden of proof for these types of hardship determinations is extremely demanding and requires the applicant to show hardship substantially beyond that which would normally be expected from the separation of an individual with close family ties here in the United States. Here, petitioner has shown that he has a loving family that will be deeply distraught if he returns to Mexico, where he will likely not be able to provide the same level of financial support and emotional support. However, this type of hardship is not exceptional and extremely unusual. Rather, this level of hardship is common and is the type that often arises when a parent is separated and then returns to a country that has fewer economic opportunities. Moreover, petitioner has not identified any record evidence that would compel the conclusion that he has shown exceptional and extremely unusual hardship to any of his qualifying relatives. For these reasons, the court should dismiss or deny the petition for review. If the court doesn't have any questions, we're happy to rest on the brief.
Do you have anything else? Thank you, sir.
Thank you, Your Honor.
Mr. Baczynski, anything else?
No, Your Honors, unless there are any questions.
Nope.
Could I just would like to ask you, when I asked you about precedent, you cited an agency decision, and I didn't hear the name clearly.
Mendoza, Andazola. It's in at least the reply brief. I don't recall
Okay.
if it's in the opening.
Thank you.
Thank you. Thank you, counsel. We'll take the case under advisement. That is our last case of the day, and so we're adjourned.